This is Michael Popok, so it must be time for Legal AF After Dark. The United States Supreme Court has effectively granted Donald Trump's motion to dismiss on immunity grounds his criminal indictment in D.C. election interference case. What am I talking about? Look at the delay. We're going to be pushing 150 days of delay since the oral argument in April, and we're still waiting on the immunity decision. What does it mean for the case? Is there a way for Judge Chutkan, the trial court judge, to restart the case in time and get it tried before the November election? This is the special counsel 4-count case against Donald Trump for election interference, the heart of the Jan 6 prosecutions, if you will. And what will happen with 2 of his 4 counts for obstruction of Congress? Is that going to survive the United States Supreme Court rulings that we expect probably this upcoming week? We break it all down for you right here on Legal AF. Take a listen.
Michael, share with us, if you can, not just, we talked about what the Supreme Court ruled on, the fact that they have not ruled on the absolute immunity decision, the fact that they have not ruled on the obstruction of official proceeding, that they are waiting so late in the term. Tell us about the import of that.
Yeah, I'm going to do that. I wanted to make one comment for our legal AFers. This whole originalist textualist thing that you talked about is really, as you said, a sham. Even the United States Supreme Court, its role in our society, its function and its interpretive function of finding, at least for constitutional law, whether there is a constitutional violation or not, is not found in the literal text of the U.S. Constitution. It's nowhere. We can spend time, we can throw up the Constitution that talks about the Supreme Court, and it's nowhere to be found. Why? Because it's an interpretive result of John Marshall, the Chief Justice in the 1800s, in a case called Marbury versus Madison. If it wasn't for Marbury versus Madison and John Marshall, and if you go to the Supreme Court, like I did with my wife a couple months ago, there's a huge statue, 2 of them, but one giant one of John Marshall, for good reason. There would not be a United States Supreme Court. But that's all from interpretation, not from the original text. It's irony that, of course, is always lost on MAGA. In terms of the timing issue, Judge Chutkan, we always, sometimes when I go to a movie and they do all the previews, I forget what movie I'm about to watch. And we forget about Judge Chutkan. She has been patiently waiting with a pin in her case for all this time. When I said it's 114 days, 115 days since oral argument, it's even further back, almost 3 months further back from when she put a pin in the case while the immunity issue is being fully litigated at the D.C. Court of Appeals level, 3-judge panel. Then, and just to remind everybody, the special counsel tried to short circuit and go right to the United States Supreme Court and demand an immediate appeal issue so that they would make the decision in the first instance back in November and December, not the DC Circuit Court of Appeals. They said, no, we want a record. We like when records go fully up on appeal from the lower court. Let's jump through all those hoops. So that takes a minute. And then you and I sat around tapping our foot, waiting for a month to go by, which we thought was sort of long. But, in retrospect, we shouldn't have faulted the D.C. Circuit Court for making their ruling. And of course, there was no immunity for crimes like this, personal crimes that benefited Donald Trump to try to cling to power. And then every time that Supreme Court had an opportunity, led by MAGA, to benefit Donald Trump, they did. Let's do oral argument, but let's do it on the very last day of the calendar, literally the last oral argument we're going to hear. All right, that was end of April. And now, should we issue the order, the decision at the beginning when we start issuing orders and decisions, or should we wait until the last day in July, apparently, or maybe next week, although I doubt it, right before we go up on our plate? Let's do it then. We'll do it the last day. And why this impacts, of course, Judge Chutkan, is she has already said that whenever I get the case back, and I want to talk about what kind of case she gets back, assuming she can just go right back to trial on the indictment, and I'm not sure that's a foregone conclusion, she has said, I'm going to add 89 days. I'm going to add 90 days for prep, because that's where we were when the case was put on ice back when the immunity appeal was taken. So plus 9, let's just do plus 90. Let's say she gets the case middle of July. She calls everybody in. She says, we're going back to trial. This is the direction I've been given by the mandate of the Supreme Court, and this is how I'm going to do it, assuming it's that easy. Then if you add 3 months, middle of July, August, September, October, talk about an October surprise. The October surprise is going to be, how can she possibly get this case up and running a month before the people, 3 weeks before the people vote? Not happening. And that is what, as you said, they gave Donald Trump immunity, and an immunity and holding America hostage so that the American electorate doesn't have what they need to make a fair decision about whether they're voting for a former president who's a one-time felon or a two-time felon for two different things, including presidential election interference, which is important to our democracy, but not to this United States Supreme Court. So they're waiting till the very end. And I'm not even sure that at the very end, it's a decision. They could, I know this is going to freak people out, they could ask for re-argument. The Supreme Court could say, you know what, there's an issue that wasn't really fully briefed. Let's have some mini rebriefing and a new argument that we'll hold maybe over the summer. I mean, they've held arguments over the summer before. The special counsel, special prosecutor Leon Jaworski thing happened in July after the term had ended. So they can get all back together again when it's important. So they could, and what does that do? Another day, another delay, another disconnect with justice. And so that's what we're watching. And then what they've done is, as we said earlier, is they sort of staged and sequenced how they're dribbing and drabbing and spoon feeding us their decisions. Let's front load all the ones where it looks like we're getting along. 6-3, 7-2, a couple in there that are, well, the 6-3s aren't. The 7-2s and the 8-1s and the 9-0s, those are the ones they're front loading with a couple smattered in there. And we'll give them abortion, medicated abortion, and we'll take away domestic violence abusers' gun rights and things that people can try to rebuild the integrity and the integrity and the respect for the Supreme Court until they drop simultaneously, probably, the decision about whether all the Jan 6 insurrectionists, including Donald Trump, can be tried for and indicted for obstruction of an official proceeding. Donald Trump having a special extra that probably keeps those claims in front of him because of the fake elector certificates, and this decision about immunity. And then lastly, even if there's no re-argument, they actually issue a decision, which is the next wave is going to come on June 28th. And to answer the question in the chat, who sets the time and how they run their cases, their dockets, their calendars, and their opinion dropping? The Supreme Court and the majority of the Supreme Court. There's no rule, there's no regulation, there's no Judiciary Act of 1787. Nothing controls them. And if they want to do re-argument, they're going to do re-argument if they have the votes. So if they issue their order and they send it back to Judge Chutkan, I'll leave it on this. And the direction to Judge Chutkan is use our decision and figure out which of the indictment issues fall into the personal benefit category and which is official conduct category, and do that in an evidentiary hearing. Add another 30, 50, 60 days onto this, and we're well beyond it. And if Donald Trump, if the people of this country want to restore not just a president who commits criminal acts while he's in office, but a criminal president back into office, he's going to dismiss all the federal. He's going to order his new Department of Justice to dismiss all the cases against him. He's going to give immunity to wherever he can, and he'll deal with the state court proceedings as needed. So we have to see what the directions are even back to Judge Chutkan. If she has to hold another hearing, another briefing, it's done. It's over. It's basically over now. If she can do something else, if she on her own can just say, I'm going to take a razor here and I'm going to split the indictment in this way, or I'm going to with the jury instructions, let the jury handle it. It depends on what the opinion is going to say that you and I are frothing at the mouth in order to read and bring to our audience. And that one, Ben, if there's going to be a reading of dissents, and there will be, depending upon what decision will be, we should try to get a live stream on that, and you and I and the other contributors get on there and talk about it. Welcome back. That was Legal AF, a little podcast that we do every Wednesday and Saturday at 8 p.m. Eastern Time, right here on the MeidasTouch Network. It's an hour long or so. If you didn't know why we called it Legal AF, now you know. And if you don't, join us. I invite you to Wednesdays, Saturdays, 8 p.m. Eastern Time at all major podcast platforms as well. We curate the top 4 or 5 stories at the intersection of law and politics, and we bring it to you the only way we know how, without blowing smoke or sunshine. We just tell you straight, unplugged, sometimes unhinged, but it's lawyers talking about things they know what they're talking about at the intersection of law and politics. If you know all about Legal AF, you're already part of our audience. I want to thank you for being there and some of you from the very beginning, almost 4 years ago. Send that off, though, to friends and family. Be our ad hoc marketing department. We need one. We're building this network with our bare hands with your help, and ask them to become part of our audience. And then if you don't know about Legal AF, that was a little bite-sized version. And if you liked it and you want more, come Wednesdays, Saturdays at 8 p.m. Eastern time right here. Free subscribe to the MeidasTouch YouTube channel. You ever hear those words? Free subscriptions, no paywall ever. You've reached it right here. And then if you like what we're doing, you can follow all of the contributors to Legal AF on MeidasTouch Network. So until my next Legal AF, till my next hot take, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.